Libadde essanyu jjereere omukulembeze w'eggwanga His Excellency Kyagulanyi Ssentamu Robert Bobi Wine bwe twogerera kati ng'amaze okununula mukwano gwe era munnabyabufuzi munne omukulu litaali Dr. Kizza Besigye olunaku olwaleero wano mu kkooti y'amagye e Makindye. Kyagulanyi Ssentamu Robert Bobi Wine yali yeebalama dda ebintu by'okujja mu kkooti naye olunaku olwaleero lwazze mu kkooti omukulu amaze okuba nga ayimbulwa. So baganda bange nga tewali kutya nga tewali gamba ki twebaze bwebaza His Excellency Kyagulanyi Ssentamu Robert Bobi Wine kwekyo kyakoze okubanga tukola buli kimu ekisoboka okulaba nga tununula mukwano gwaffe muganda waffe retired Dr. Kizza Besigye. Webale nnyo President n'omutima gwo omulungi ogwagaliza omutima ogw'okwewaayo gw'olina bannange tusiimye nnyo. Tusaba Katonda ayongere okutukuumira n'okututangaaliza ate n'okutubeereramu okulaba nga tutereeza eggwanga lyaffe. Tulina okukkiriza nti ke kano akaseera akatuufu ke tulina okukoleramu ebyamagero ebitwala Uganda eno mu maaso era eby'okutubeererawo. Era twongera obajjukiza baganda baffe mikwano gyaffe nti agali awamu geegaluma ennyama. Tusiimye nnyo enkolagana ya His Excellency Elected President of Uganda Kyagulanyi Ssentamu Robert Bobi Wine gy'akoze okulaba nga abaako ekyenjawulo ky'agatta tutereeze eggwanga lyaffe. President alwanye okulaba nga omukulu Dr. Kizza Besigye ava mu Komeera era olunaku olwaleero bwe yataddemu engatto agende ku kkooti wano e Makindye okununula lita Dr. Kizza Besigye obusajja butidde bwe butyo ne bumuyimbula. Congratulations.
So I think I have vindicated. Yes, because my report is starting with the one of registrar. Why are you saying that I'm writing my own things?
That one was finished. Let us proceed.
Mr. Chairman,
I was council seat. I was asking that Kizza Besigye, have you had understood the charge read to you in count one?
I have heard and I have responded that I have objections to taking plea on this charge and requested my lawyers present my objections.
You are right, but at this moment I'm asking you, the chosen person, if you don't accept, you say I don't accept. If you accept, you say yes, I accept.
Accept what?
There are two things. If you have had understood, another question is, do you accept or you don't accept?
Accept what?
Help to you, Mr.
Do I
Chairman.
plead guilty or not guilty? Or you want me to take a plea?
He has invoked Rule 23 that he is objecting to taking plea.
Yes.
And therefore it may not be fair to ask him whether he accepts when he clearly invokes Rule 23 and it allows him to do what he is doing. So maybe you could allow, on his behalf, Council Elias Lukwago to raise the objections on his behalf as he has asked us to do, instructed us to do.
I think, sir, they are taking us backwards. Exactly. That's what the registrar has read. It's the same objection that was overruled. So we cannot go back to where we started before.
Please, no, I've not allowed anybody now to talk.
Thank you, Mr. Chair.
Because now you are taking us back and it's true. Yes, it is a new charge. Now what if just now the one you are pushing for is corrected? Will he accept or he will not accept? So the issue is we have read the charge sheet. It is the chosen person to plead guilty or not to plead guilty, and then you can start from there.
Thank you very much, Mr. Chairman. Mr. Chairman, my learned friend, the JA, rightly pointed to the court adopting rules of amendment of criminal charges, and also pointed out to any amendment which can be done which doesn't prejudice the accused person. That is correct, and it's on that basis that the court made a ruling regarding the amendment. My colleague will agree that once an amendment has been made, the process which was running before comes to an end and starts afresh with the new amendment. The charges we have now, clearly, from looking at the amended charge sheet dated today and the one before, are distinct. So essentially what the prosecutor has done is to start again the process which started in November. So the objections which were made then, if any, cannot be carried on by infection to the current charge sheet. To the extent that the accused person has seen and has new objections, because this is now a fresh charge sheet, Mr. Chairman, as the JA will agree with me, they are entitled to make the objections. They might be boring, they might be the same, they might be repetitive, but in a dispensation when we are saying it is his right, it is his right to make the objection. What we request is for court to listen kindly, and then also, as my learned friend has advised, and the JA, if we do it together, Regulation 23, kindly. It says, Mr. Chairman, before pleading to the charge, the accused person may offer a plea to the jurisdiction. And if he does so, the accused person may adduce evidence in support of the plea, and the prosecutor may adduce evidence in answer to that evidence, and the prosecutor may address the court in answer to the plea, and the accused may reply. Mr. Chairman, Regulation 23(1) applies before taking a plea. It is not even saying at the time, it says before. It also says that the accused person may. When it applies may, Mr. Chairman, it gives the accused person a discretion. What we understand now, Mr. Chairman and members of the court, is that the accused person has chosen to exercise their right to raise an objection. We have not listened to the objection because, according to the accused person in the dock, he has asked his lawyer to make the objection. So, my Lord, in that regard, we would be inclined, if we are to agree that we follow this procedure of this court, we are enjoined to listen so that the state may respond, and then the court will make a pronouncement. That is what, Mr. Chairman, we understand from the clear. It is before. So, Mr. Chairman, when the accused is asked whether he understands, we understand that to be part of the plea-taking process. Yet the rule requires that before that process begins, he has the right to raise the objection. We humbly pray, Mr. Chairman, that we abide by this regulation. We kindly request, Mr. Chairman. Thank you, Mr. Chairman.
I also concur with the council FK. You raise your objections, let the state reply.
Violation of Article 23 and 28 of the Constitution of the Republic of Uganda, if you proceeded to entertain this matter. Mr. Chairman, the Constitution confines the jurisdiction of this Honorable Court Martial to matters relating to offences allegedly committed within the territory of Uganda. Mr. Chairman, under Article 23, 28:12, no person shall be convicted of a criminal offence unless the offence is defined and the penalty for it prescribed by law. And also yes, I'm coming to Article 28:7 as well. You read, if I may be permitted to make my case. No person shall be charged with or convicted of a criminal offence which is founded on an act or commission that did not, at the time it took place, constitute a criminal offence. Mr. Chairman, when you look at the charge sheet, the particulars allege that while in Athens and in Greece, rather in Geneva, Switzerland, and also Kenya, in Nairobi, Kenya, the accused persons are alleged to have committed those offences, particularly the allegations that they were found in possession of weapons which are ordinarily a monopoly of defense forces. Mr. Chairman, weapons in Kenya, or military hardware in Kenya, or Athens, or in Geneva, cannot be a monopoly of UPDF. The UPDF Act specifically talks about weapons which are a monopoly of UPDF, not the defense forces or security forces of Switzerland, of Greece, or of Kenya. When you look at the provisions of Article 28:7, those acts, the impandi acts spelled out in the charge sheet, would only constitute offences in those countries, either in Kenya, in Switzerland, or in Greece. because Mr. Chairman, the particulars here, they are talking Colonel Dr. Kizza Besigye, while at Riverside apartment in Nairobi, Kenya, were found in unlawful possession of a pistol model this, which is ordinarily a monopoly of the defense forces. Mr. Chairman, this one has two limbs. One, the defense forces are not defined. Are you talking about the defense forces of Uganda, of Kenya, of Greece, or of the European? They are not defined here. And that is one of the nations, but also on regulations, particularly regulation 22. Regulation 22 provides us for an accused may, before pleading a charge, object to it on the grounds that it's not correct in the law or that it's not framed in accordance with these regulations. And if he does so, the prosecutor may address the court in answer to the objection, and the accused may reply to the prosecutor's address. This is regulation 22 of your regulations here. An accused may, before pleading to the charge, object to it on grounds that it is not correct in the law and that it is not framed in accordance with these regulations. So this is a defective charge sheet. This is our contention here. That it's not framed in accordance with the UPDF. The UPDF Act. It's not framed in accordance with the UPDF Act 2005 because purporting to bring into the confines of this court, the jurisdiction of court, matters which relate to weapons of other countries, defense forces, this case that is in the defense forces or elsewhere. Because if it were a charge relating to offenses under the UPDF Act, specifically they will be stated here that contrary to a particular provision which talks about multiple points which are ordinarily a monopoly of the UPDF. But here they are talking to contrary to defense forces. So the presumption is that Scott Marshall has jurisdiction all over the world. That is universal jurisdiction. That whoever is found in possession of any weapon which is alleged to be a monopoly of defense forces, not UPDF, for defense forces worldwide, then this honorable has got to be done. So that offense regulation 22 and the charge sheet becomes effective. It's not correct in law, it's not framed in accordance with the UPDF Act. Then the other limb of the argument, Mr. Chairman, is in relation to the way the accused persons were transferred from Kenya and from here. Mr. Chairman, our contention is that this honorable court has been jurisdiction whatsoever to deal with accused persons who are not processed in accordance with the laws of Uganda or who are handled in a manner that violates international law. And I will refer you to a number of authorities which we have here. Mr. Chairman, I have the Ugandan case of Omar Owadi and 10 others versus the Attorney General. It's a consolidated constitutional petition number 55 and 56 of 2011.
But Mr. Chairman, inference was made a number of decisions that have been taken by other Commonwealth countries. First of all, Mr. Chairman, they made a difference in the case of Regina versus Horsefed Road Magistrates Court in 1994, SC Volume 1, page 42, where the House of Lords gave a genesis to the jurisprudence relating to matters of this nature. And this is what they have to say. English common law regarding irregular apprehension of an offender abroad and the jurisdiction of English courts to try such an offender was examined by the House of Lords in that case of Regina versus Horsefed. The earlier approach of the English courts has been that once a suspect is in lawful custody, substances, and charged with an offense, which that court has jurisdiction here, the court has no power and is not concerned with inquiry into the circumstances in which it may have been brought into its jurisdiction. It was no answer to a charge that such person was arrested or put in contrary to the laws of the state of F. That was the jurisprudence and the practice at the base. And the House of Lords had to pass that position, and this is what it has to say. This is now the common law position on issues to do with the people.
So these accused persons were illegally brought here before you, and now the charge sheet prepared is in different offenses allegedly committed in Kenya. The authorities who have cited here are very, very clear that we do not have jurisdiction in such cases. The one we have talked about of South Africa, it involved the illegal rendition of a particular individual from a neighboring country to South Africa. You'll find it, the facts you'll find them in that particular case. The case was dismissed. You see, this is illegal because since there was killing this particular individual from a neighboring country and brought to South Africa, they couldn't be tried in South Africa. Which is the case here. Now you are being asked, Mr. Chairman, to entertain and try a matter which did not go through those legal processes, which is a violation of international law and a violation of our constitution, and essentially the proceedings rooted in reality where we do not have jurisdiction to handle this matter. So that is our contention in this particular case, and it is the reason we are saying at this stage, under Regulation 22 and 23, Dr. Besigye and Dr. are not taking fully the charges which are penalty charges, which are different charges which offend the laws of Uganda and the international law. So we pray that you be pleased to strike out the charge sheet and discharge the accused persons. We do so pray.
If I may add to that, just to confirm that the extradition law of Kenya is similar to that of Uganda, that the constitution of Kenya is similar in terms of rights and the requirements of due process to the constitution of Uganda. In both countries, due process is emphasized. And therefore, as has been ably demonstrated by Council Elias Lukwago, the fact that agents of the state of Uganda arrested or abducted the two gentlemen from Kenya and brought him back without any